Hi, I'm Callum Monro Morrison, and with me is Elizabeth Donnelly. We are junior barristers at Keating Chambers, and we're going to talk to you today about adjudication enforcement, particularly natural justice challenges. First of all, I'm going to talk about what are natural justice challenges, what is natural justice, what does it mean in adjudication, and how that concept has developed through the case law. And then Elizabeth's going to talk about some more specific natural justice objections which are commonly raised in adjudication enforcement. And then finally, we're each going to talk about a more recent case just to illustrate the court's current approach. So what is natural justice? Well, this is an umbrella term, really, and it covers various rules, some of which are more hard-edged, and some of which are more nebulous. But essentially, they're designed to ensure procedural fairness or due process. And these rules have developed over centuries, really, from pre-Roman times through the common law, and many are now enshrined in statute or in the civil procedure rules. So there are really two core overarching principles. And there are obviously Latin maxims for these, but essentially they are that no person shall be a judge in their own cause, and a person's case must be fairly heard, or the right to a fair hearing. Importantly, what we're talking about here is procedure. So natural justice is concerned with the manner in which decisions are reached. It's not about the correctness of the decision itself. So a wrong decision will not be a breach of natural justice if it's been reached in the right way, and that's an important point of principle to keep in mind. So how and why does natural justice apply to adjudication? Well, as decision makers, adjudicators are under an express duty to act impartially between the parties, and this duty has a statutory footing. So Section 108(2)(e) of the Housing Grants, Construction and Regeneration Act requires construction contracts, as defined in the Act, to contain a provision imposing a duty on adjudicators to act impartially. And of course, if a construction contract doesn't contain such a provision, then the scheme will apply, and the scheme itself imposes that duty on the adjudicator. And as you can see from the quotation at the bottom of the screen, the scheme also requires adjudicators to decide disputes in accordance with the terms of the construction contract and applicable law. However, as we shall see, errors of law do not necessarily amount to breaches of natural justice, whereas a failure to act impartially will. So what does it mean for the adjudicator to act impartially in adjudication? Well, there was a suggestion in early case law in the late 90s and early 2000s that adjudicators were not subject to the same rules of natural justice as arbitrators and judges, and that procedural errors would not vitiate adjudication decisions. But it was swiftly clarified in the Court of Appeal that adjudicators do have a duty to comply with the rules of natural justice, and that's the case of AMEC Capital Projects and Whitefriars City Estates. However, adjudicators are not held to the same standards as arbitrators and judges. And that is a necessary consequence of the tight timescales within which adjudicators are required to operate, the provisional nature of their decisions, which can of course be overturned in a final dispute resolution process, i.e. court or arbitration. And thirdly, although not on screen, it's relevant that many or most adjudicators do not have legal backgrounds. They tend to come from the construction industry rather than the legal sector, and that's a factor which various judges have mentioned. And this whole concept was neatly summed up by Lord Justice Chadwick in Carillion, which is a key authority on the nature of natural justice in adjudication. And he said, "The task of the adjudicator is to find an interim solution which meets the needs of the case. The need to have the right answer has been subordinated to the need to have an answer quickly." So in other words, if an adjudicator is validly appointed and has jurisdiction over a dispute, he has jurisdiction to get it wrong. And this is known as the doctrine of unreviewable error of an adjudicator within jurisdiction. Mistakes of fact or law will not usually invalidate an adjudication decision, and the correct recourse for an aggrieved party is a final dispute resolution process to get the right answer, as Lord Justice Chadwick called it, not challenging the adjudicator's decision or resisting enforcement on natural justice grounds. And the court's starting point is that unless there is a clear, serious and material breach of natural justice, adjudication decisions should be enforced. And that's part of the policy of adjudication enforcement, which is the pay now, argue later objective of the legislation. So Lord Justice Buxton said in Bouygues and Dahl-Jensen that the possibility of a mistaken or legally incorrect outcome was inherent in the exceptional summary procedure provided by the 1996 Act. In any event, unfairness in a specific case cannot be determinative of the true construction or effect of the scheme in general. And in the case of Bouygues, the Court of Appeal had facts and circumstances which were almost ideally suited to demonstrating the draconian nature of the statutory effect of adjudication. So in that case, the way in which the adjudicator dealt with the account calculation had the effect of awarding to Dahl-Jensen all of the retention monies. And his mistake was in using as a starting point the full contract sum, which was the gross amount that took no account of deduction or retention. So the adjudicator made a calculation error, almost an arithmetical error, and the overall winner in the adjudication won solely by virtue of the mistake. At first instance, Mr. Justice Dyson, as he then was, considered the mistake made was one which it was within the adjudicator's jurisdiction to make, and it's difficult to disagree with that. An arithmetical error is, of course, part of the risk that parties to a procedure like adjudication run. Another useful summary quotation from Lord Justice Chadwick in Carillion is at the bottom of the screen. The objective which underlies the Construction Act and the statutory scheme requires the courts to respect and enforce the adjudicator's decision, unless it is plain that the question which he has decided was not the question referred to him, or the manner in which he has gone about his task is obviously unfair. So the first bit of that, whether the question was referred to him, is a jurisdictional issue, and the latter part of that quotation, the manner in which the adjudicator has gone about his task is obviously unfair. That is a matter of natural justice. So what is required for the court to find that the manner in which an adjudicator went about his task was obviously unfair? Well, the case law has clarified that the breach must be serious and it must be material, which are really two sides of the same coin. So in Balfour Beatty, His Honour Judge Humphrey Lloyd QC found that constructing or reconstructing a party's case for it without confronting the other party with it is such a potentially serious breach of the requirement of either impartiality or fairness that the decision is invalid, for it is not a decision which the adjudicator was authorised to make. And this is the principle which Mr. Justice Aikenhead later referred to as the adjudicator going off on a frolic of his own. It's not for the adjudicator to make up what a party's case should be, and particularly not if he's not going to give the other party a chance to comment on it. So in Cantillon and Ervasco, the second bullet point, which is a leading authority on natural justice challenges, Mr. Justice Aikenhead analysed the decision in Balfour Beatty, as well as other case law, and set out some useful general principles. First, it must be established that the adjudicator failed to apply the rules of natural justice. Secondly, any breach of the rules must be more than peripheral, it must be material, as we've mentioned. Thirdly, breaches of the rules will be material in cases where the adjudicator has failed to bring to the attention of the parties a point or issue which they ought to have been given the opportunity to comment upon. And of course, it's only where the point or issue is one which is either decisive or of considerable importance to the outcome of the resolution of a dispute, not peripheral. Whether an issue is decisive or of considerable importance is obviously a question of degree, and that has to be assessed by the judge in any case. It's only if the adjudicator goes off on a frolic of his own, as the judge put it, that is, wishing to decide a case upon a factual or legal basis which has not been argued or put forward by either side, without giving the parties an opportunity to comment, that you would be in a Balfour Beatty set of circumstances. So if either party has argued a point and the other party does not come back on the point, that is not a breach of the rules of natural justice. And finally, then, in assessing whether a breach of natural justice is material, the court will consider the nature of the question or dispute that the adjudicator was deciding, and how widely or narrowly the dispute was circumscribed. And that's fairly obvious, but it's obviously necessary to consider those things to determine how far the breach of natural justice actually affected the outcome. So very briefly, the two main categories of breach of natural justice are firstly bias, and secondly, failure to give the parties a fair hearing. As to bias, this goes back to the first core principle I mentioned, which is that no person should be a judge in their own cause. By extension, decision makers who have been influenced or corrupted by one of the parties are not allowed. And the important point in relation to bias is that it's not just actual bias, such as a direct financial interest in one of the parties, which counts. Apparent bias is also prohibited. And that's because, as the first quotation says, justice should not only be done, but should manifestly and undoubtedly be seen to be done. So apparent bias arises where, as Lord Hope said, the circumstances would lead a fair-minded observer to conclude that the tribunal was biased. Not relevant to bias, however, are the factors set out in the final bullet point on screen. As to the right to a fair hearing, this goes back to the second core principle I mentioned. There are a few different aspects to the right to a fair hearing, but I think the most essential one on the adjudication, or in the adjudication context rather, is that parties have the right to know and effectively challenge the opposing case. This means that ambushes should not be permitted, including by the adjudicator going on a frolic of his own, and parties should be given the opportunity to respond to anything said against them. Of course, the aggrieved party must still show they have suffered real prejudice as a result of the unfairness, and that's really just another formulation of the materiality test that I mentioned. So against the backdrop of these general principles, I'm going to hand over to Elizabeth now to take you through some more specific points about the sorts of natural justice challenges which frequently arise.
Thanks, Callum. So we're now moving on to look at some of the most commonly raised natural justice objections in circumstances where a party wants to resist the enforcement of an adjudicator's decision. And as Callum said, the party resisting enforcement of the decision must show that there's been a material breach of the rules of natural justice and that the party suffered real prejudice as a result. Of course, a natural justice objection may be deployed, but it's not always successful. And the Court of Appeal made clear in the Carillion case that save in the plainest of cases, it's likely to be a substantial waste of time and money to try and resist enforcement of an adjudicator's decision for breach of natural justice rules. Here on the slide, I have three common objections, which we'll be looking at in a little more detail. The first is where the adjudicator refused to consider certain information or evidence. The second is where a party argues that it was deprived of the opportunity to make representations in the course of the adjudication. And the third will be where an adjudicator has used their own knowledge to decide one or more issues in the adjudication without telling the parties about it, or where maybe the adjudicator has spoken to a third party for advice or guidance and has not alerted the parties to that fact. So here we have a slide which is relevant to the first common objection, where an adjudicator has refused to consider certain evidence or certain information. So it's important to understand at the outset that it's unlikely to be a breach of natural justice if the adjudicator declined to consider evidence or information on the basis that on his or her analysis of the facts and the law of the dispute in question, the evidence simply wasn't relevant. It's sufficient for the adjudicator to be aware that that evidence or information exists and to have considered whether or not to actually take it into account or to look at it in detail. But as Callum said, breach of natural justice is not about reaching the correct decision. It's about reaching a decision in the correct way. And a party might disagree with the adjudicator's decision not to consider evidence or not to give it any weight or take it into account in any significant way, but that does not automatically amount to a breach of natural justice rules. But what if the adjudicator fails to consider relevant evidence or information which was placed before him and just entirely disregards it? This may be a breach of natural justice, as we will see in these cases. So at the outset, in the pylon case, the TCC made clear that if there has been a deliberate decision by the decision maker, such as an adjudicator, not to consider a defence to a claim, then that clearly prejudices the defendant or the responding party to an adjudication, and it's a breach of the rules of natural justice. This is a pretty well-established principle now, to the extent that we can really consider it to be trite law. Slightly different is where an adjudicator might have accidentally or inadvertently failed to consider certain evidence on a particular issue. This won't always or ordinarily render the decision unenforceable. And on the slide, I've got a quote from the TCC in KAN Coburn and GD City Holdings, where the judge said that the touchstone should be whether the inadvertent failure means that the adjudicator has not effectively addressed the major issues raised on either side. When confronted by a reasoned decision, the court, so that will be when the court is deciding whether or not to enforce the decision of the adjudicator, the court should tend to look for coherent reasoning underpinning the adjudicator's decision, rather than the hastening to a conclusion that an omission renders a decision unjust. Finally, in a very recent case, Wordsworth and Innovos, which Callum will be discussing in a bit more detail shortly, the TCC has provided further commentary or obiter on this issue, and made clear that even if it's an accident or inadvertent, sometimes it can be a breach of the natural justice rules if the adjudicator hasn't taken certain evidence or information into account. It's a decision that could be made on certain extraordinary facts, so it will be a rare case. But any defence to an enforcement of an adjudication award on the grounds of breach of natural justice has to be material and of sufficient seriousness. So, as ever, there's no clear-cut answer. Really just depends on the facts of the case. Another common objection, the second one I'll be looking at, is when a party argues that it was deprived of an opportunity to make representations. At the outset, we should note that if the referring party, so the party who's referred the dispute to adjudication, did so in a way that could be considered an ambush, that's not automatically a breach of the rules of natural justice. Some people watching this webinar will likely be aware of the discussions that are commonly had in the profession, in the industry, around when is a good time to start an adjudication. Should a dispute be referred to adjudication during Christmas, for example? Might that put the responding party on the back foot if it's the holiday period? Well, the Construction Act makes clear that a dispute may be referred to adjudication at any time. So-called ambushes are allowed. Ambush isn't a term of art or an established legal principle, but it's a word that is used in a lot of the commentary around adjudication, enforcement, and breach of natural justice. But any ambush, any sudden start of an adjudication which takes the responding party by surprise, will not necessarily, or will rarely be, a breach of the natural justice rules. What's important is that the adjudicator gives the responding party a reasonable opportunity to respond. And in the case of Bovis and trustees of the London Clinic, the case citations on the slide there, Mr. Justice Aikenhead, sitting in the TCC, looked closely at the behaviour of the responding party during the adjudication. The responding party later tried to resist enforcement of the adjudicator's decision and said that they didn't consider themselves to have had enough time to respond to the issues and give their submissions. And the judge pointed out that at no point in the adjudication had the responding party actually raised any concerns with the adjudicator or argued that they hadn't had sufficient time to deal with all issues and make representations. So if anyone wants to try and resist enforcement of a decision on the basis that the responding party was ambushed or didn't have enough time, bear in mind that the court will look closely at how that responding party behaved during the course of the adjudication. A few more examples where a responding party may say, or any party in fact, may say that they didn't have time to make representations. In RSL and Stanzel, case from a while ago, but the principles are still very applicable to the law and the state of things today. The TCC said that it's absolutely essential for an adjudicator, if he is to observe the rules of natural justice, to give the parties to the adjudication the chance to comment upon any material from whatever source, including the knowledge or experience of the adjudicator himself, to which the adjudicator is minded to attribute significance in reaching his decision. So importantly, if the adjudicator is taking into account other facts, information, evidence of which the parties may not be aware and doesn't tell the parties about that, and therefore, or thereby depriving them of an opportunity to make representations, that could arguably, fact dependent of course, but it may arise or give rise to a breach of the natural justice rules. Finally, for this section, I've got a couple more cases on the slide where the court considered instances where, for example, the adjudicator had failed to consult with one party to an adjudication about submissions made by the other party. That was a breach of natural justice, perhaps unsurprisingly. And then if new substantial information is produced by a party in the course of the adjudication and the other party is not given reasonable time to address it, that may be a breach of natural justice. But it's really up to the party to argue that, and simply a failure or forgetting to address and appoint an issue is not the same thing. And that will not necessarily render the adjudicator's decision unenforceable. Finally, the third and final common objection that we're looking at today is where the adjudicator has relied on his or her own knowledge or has consulted perhaps a third party to the adjudication, seeking advice or information in order to reach a decision, and the parties have not been told about this. I've got two cases or case citations on the slide. Both of these are actually judgments of the outer house of the Court of Session. So they are Scottish cases, Scotland, of course, being a different jurisdiction. So any decisions made by the higher courts in Scotland will not bind the High Court or any court in England and Wales. But they're still judgments sometimes worth looking at if researching potential arguments for an adjudication enforcement case. They may be persuasive. They show how judges generally might apply the principles of natural justice. And so these cases are certainly worth looking at and remembering when considering enforcement issues around the topic that we're looking at today. So that's all from me on the common objections. I'm going to pass back to Callum now, who will look at the first of our two recent cases, looking at how the courts are applying the principles to adjudication enforcement applications.
Thank you. So the case I'm going to talk about is Wordsworth construction and Innovos, which is a decision of Recorder Andrew Singer KC, sitting as a TCC judge. And I think the decision well illustrates the continuing tough stance of the TCC on natural justice challenges. So in this case, the court was faced with cross applications by each of the parties to enforce two separate adjudication decisions. And one issue was actually the extent of the overlap between the two adjudication decisions, but that's a jurisdictional question rather than a natural justice one. So the enforcement of the first adjudication decision was challenged on natural justice grounds, in that it was said by the party resisting enforcement that the adjudicator had firstly failed to decide the counterclaims at all, secondly failed to give reasons for his decision on the counterclaims, and or thirdly dismissed those claims on grounds which neither party had argued. So as you can see, that those points overlap with quite a lot of what's been said already in this webinar. So in relation to the first point, the court held that the first decision would be enforced even though the counterclaims had been dismissed for reasons which were wrong in law. So the adjudicator hadn't refused to consider or decide the counterclaims, the court found, which would have been a breach of natural justice. He'd simply dismissed them on an erroneous legal basis, which he had jurisdiction to do. So that's the doctrine of unreviewable error of an adjudicator within jurisdiction in action, as I mentioned earlier. As to the second point, the adjudicator had provided reasons, even if they were very brief and wrong in law. So as you can see, quite a strict stance on that. And this argument by the party resisting enforcement was, as the judge said, an attempt to argue that there was a refusal to decide these items by another route. As to the third point, the court found that the adjudicator had not gone off on a frolic of his own. The party resisting enforcement had itself made unclear submissions as to the status of the counterclaims if the termination point was decided against it, that there was a termination issue in the first adjudication. So that last point is quite interesting and quite significant, because the court was clearly of the view that to the extent that the resisting party had itself contributed to the outcome with a lack of clarity in its submissions in the adjudication, even if inadvertently, it should not be permitted to benefit from that at the enforcement stage. I'll just hand back to Elizabeth now.
Thanks, Callum. So the final case that we'll look at today is a judgment of Mr. Justice Constable sitting in the TCC in 2003, AZ and BY. This was a judgment redacted in parts, and parties, as the case title shows, have remained anonymous, because this was a case in which there was a real question as to whether the adjudicator had been biased, or whether there was apparent bias in circumstances where one party to an adjudication had disclosed or provided the adjudicator without prejudice material, which could have influenced the adjudicator and even subconsciously led the adjudicator to be biased. Without prejudice material, of course, principle of without prejudice privilege is where documents or communications are confidential and cannot ordinarily be disclosed to the courts or any decision maker in an adjudication as well. For example, in circumstances where the parties may have been in settlement negotiations, and anything they say in the course of those communications or documents has without prejudice privilege attached to it. That's very basic description or summary of when without prejudice privilege might attach to a document. But the bottom line is that a party in the adjudication, in this case, had shown the adjudicator documents which the adjudicator should not have been allowed to see. And there was an inevitable question mark, according to Mr. Justice Constable, as to whether the adjudicator had been inadvertently or subconsciously biased as a result when making the decision in the adjudicator. At paragraph 16 of the judgment, the judge in this case set out quite helpfully his thinking about without prejudice privilege and how it was relevant in this case, and certainly within the context of adjudication. And later on in his judgment, at paragraph 25, the judge said it is trite that generally adjudicators' decisions will be enforced notwithstanding the fact that they contain an error of law, but an error as to the admissibility of without prejudice material is an error of law that could potentially impact the fairness of the decision-making process in accordance with the rules of natural justice. And his conclusion was that, in my judgment, I conclude that the fair-minded and informed observer, considering all of the circumstances of this case, would conclude that there was a real possibility that, having seen the without prejudice material, the adjudicator was unconsciously biased. In the circumstances, this is one of the few cases in which a breach of the rules of natural justice by reason of apparent bias dictates that the decision should not be enforced. Importantly, I think in this case, the TCC judge didn't find that there had been a case of actual bias. It was simply enough that there was a real risk of bias, or certainly the existence of apparent bias, for the decision to be rendered unenforceable. And there we are. I think that's all we've got today, Callum, and thank you very much, everyone, for listening.
Thanks very much.